Stuart Ritchie, an extremely warm welcome to the Humans versus Retirement podcast.
It's great to be here, Dan. Thank you.
Yeah, a very warm welcome. This is try number 2. Unfortunately, we were scheduled a few weeks ago, but you were subject to some dodgy chicken. So I'm glad you're with us and I'm glad you're feeling better.
Thank you very much.
Stuart, I can't wait to have this conversation because we're going to talk about something that I think is one of the most emotive subjects when it comes to money and life, and that is around inheritance tax. It's around our estate planning. And you've wrote a wonderful book called Who Will Get My Money When I Die? So I'd love you just to kind of spend a few minutes with me and the audience just talking about, who you are, where you've come from and your career up to date and what really led you to writing that book and the inspiration behind it.
Thank you very much. My background is I qualified as a chartered accountant and a chartered tax advisor some 35 years ago. And throughout the entirety of my career, I have specialised in what we call private client taxation. So it's the financial position and the taxation position of individuals, families, and their trustees. And I mention trustees because quite often wealth is held through trust funds. So it's individuals, families, so in other words, intergenerational, and trustees because sometimes clients choose to hold their wealth through the medium of trusts and other financial structures. When I founded my own firm, Ritchie Phillips, over 20 years ago, one of the key decisions we made was to specialise in private client taxation, and it was reflective of my experience. So when I first started out in accountancy, like most people, you get sent to the accounts and audit department, and I stayed there for 3 years and then realised that within the firm I was working, the money was actually in taxation, and that accounted for over half of the firm's revenue. And so that's the direction I took. I gained some amazing experience with that firm and the firm I then worked for. And as I mentioned, about 20 years ago, I founded Ritchie Phillips, which is a relatively small accountancy firm of myself and 10 others, where we just do some great work for individuals, families, and trustees. The book is therefore if you like, the culmination of my professional work over my working career. So it brings together all of the things that I've been involved in with clients and their other professional advisors in structuring their financial affairs and optimizing their tax position. And this is particularly important in relation to inheritance tax, which is so often described as the most hated of all forms of taxation. And the reason for that is terribly simple, that for most people, you go through life, you pay your income tax and maybe some capital gains tax and obviously other forms of tax, accumulating wealth. And then you die and the government comes along for a second bite at the cherry, shall we say. And most people I deal with find that quite grievous, the most hated form of taxation.
Yeah. And you're 100% correct. I mean, the people that I work with, when I start working with people on their retirement plans, we try not to let the tax tail wag the life dog and the planning dog, so to speak, but they're very focused on, one of the first numbers they want to understand is kind of what might inheritance tax position look like? What might be left at the end and who can get that? And what does that mean? And I think one of the most shocking numbers that you present them, particularly for people that have, you don't even need to be what I think people would describe or think is wealthy, really, to kind of have this impact you now through the way it's been kind of stealth taxed and what they're doing, etc. But you share that number with them, and it does deeply shock them, and there is an issue, I think, psychologically with that number. And I'm really intrigued that the title of your book, Stuart, Who Will Get My Money When I Die, that who bit, because there's obviously a lot of sayings there that, if you don't do this right, then you kind of, there will be someone who gets your money, and it's going to be the people or the organisation, hint, that don't want it, because the government, if not planned correctly, could get a big chunk of this. And actually, if planned well, they might not get any, right? So it's about who will get your money and how you plan to do that. You'll know this, I think, better than me, but the famous Labour Chancellor said something, didn't he? What's the quote around,
Yes, I think what he said was there's only two certainties in life, death and taxes. And it's often quoted, although it's decades old. Personally, I don't like the quote.
No.
But that's
There is another one where I think does he say that inheritance tax is only paid by people that distrust their heirs more than they distrust the government? It's kind of like that's
yes, and that's why sometimes we have trust funds.
exactly. So like when you think about all of your experience that's poured into this book, and we're going to break this down a little bit over the next kind of 45, 50, 55 minutes, what do you think are some of the biggest misconceptions that people have about inheritance tax? Because I think it can be quite sensationalist. You know, you see the headlines, you see everything like that. What are the biggest misconceptions that people may have when it comes to inheritance tax?
Well, I think the starting point is, will your estate be governed by a properly drawn up will? Or in the absence of a will you die in what's called intestate? Because if you die intestate, then it is the law of the land that determines who gets what. Whereas in this country, in the UK, we have what's called freedom of testamentary disposition, which is to be contrasted with continental Europe. So in this country, we can say, these are the people who are going to get my money and how much. Whereas if you were to, for example, go to France, there are all sorts of forced heirship rules whereby a surviving spouse, your children all get a prescribed share of your estate. So intestacy basically says this is how your estate will be distributed. And in particular, if you don't have any relatives, which can be the case, if you think of a sort of husband and wife who, through choice, have not had any children of their own, and they may not have any siblings, and those siblings may not have any children, and their parents may also have passed away. The rules of intestacy will ultimately get you to the position where your estate goes to the Duchy of Cornwall. And that, I doubt very much, is the intention of most people for their estate. Now, when the king, then the Prince of Wales, Prince Charles, was the Duke of Cornwall, anytime he received any money under this provision, he never retained it for himself, as I understand it. He always made that money over to his educational charities. And I suspect, and I'm afraid I can't remember the name of the school he went to in Scotland, but I think they were one of the beneficiaries of this provision. But for most people, I don't really think you want to see your estate going to the Duchy of Cornwall. I think most people would think that if they are going to leave any money, it'd be better left within their family or to their friends or to their own charitable interests.
I think that, Stuart, that could be something that is actually going to become more common, maybe, because, you know, I think we're getting into a generation of people where, you know, having children necessarily isn't a thing, right? I mean, it's, you know, I think if you go back a couple of generations, it was you know, you had children no matter what your beliefs or thoughts or wants were. That's just a thing that happened. And I think now going forward, I mean, I've got 2 or 3 client couples that are very much in this situation where they haven't got children through either choice or maybe medical stuff. And they're the
Yes,
only siblings.
I had an aunt who was childless, and we're talking about a couple who were married in the 50s. And she just simply said, well, it just never happened for us.
No, no.
And obviously the science has caught up a bit on that since. But there are still people out there who make that very conscious decision that they have other priorities in life.
Yeah. I mean, and I've had those conversations, right? They're the only child. They haven't got any, you know, siblings. And they have to get a bit creative with this because they don't want it, right? So it's kind of like, well, we want to make sure it's nieces and nephews and charities and all of that stuff that they need to start thinking about, which I think is really interesting. You mentioned France. I'm just intrigued because I do have listeners from all over the world, and I've got a lot of friends in America, for instance, and they simply roll their eyes and can't believe our inheritance tax system, simply because inheritance tax planning is not really a big thing over there as much as it is over here, because their thresholds are so much higher. I think it's like $12.5 million before you end up paying kind of what their version of inheritance tax is. So when I say to them, I mean, we'll get into the technicalities in a minute, but when I say to them it's like £325,000 over here, effectively, they're just like, oh my God, like what? That must be. And so I think that's getting into the system, isn't it? A lot more, you know, that information makes people think that our inheritance tax system compared to others is completely unfair and unjust, which makes them be much more proactive and about their planning.
Well, I think that's right. I've dealt with a number of circumstances where American citizens have been in the UK at the time they have passed. And under the old regime, which is of course changing, you'd be able to say, but they're not domiciled in the UK. So therefore, their wealth held outside of the UK wasn't subject to inheritance tax. But we're moving to a residence-based system, and within a short period, their worldwide wealth will be within the scope of inheritance tax, UK inheritance tax. And then we'll be looking at the extent any double tax treaties for inheritance tax can come in and save the day. So it's going to be very different, particularly on the UK-US dynamic.
So you've mentioned wills as a kind of a crucial part of this. So I think if we go to, who will get my money when I die, estate planning 101, I think the foundation of this is wills. Directing your wishes to kind of where the money and the assets, etc., go. But I'd love you just to reiterate how crucial it is to have a will, because the amount of people that I start working with that have gone, I've not got one, or I got my little binder from W.H. Smith about 10 years ago, and I just wrote it all down. One, how crucial is a will, and what happens if you die without one, and why should people undertake professional help and not just go and buy this pack off a shelf and do it themselves?
Well, I think if you go to my book, Who Will Get My Money When I Die, in the book I've produced two charts that show how the rules of intestacy work. And a measure of just how troublesome they are is if you do the first chart for an individual who is either married or in a civil partnership, basically the rule says, is your estate worth more than £322,000? So for some people, that's a relatively small amount of money. And if the answer is no, then the spouse or civil partner gets everything, and that's fine, I would suggest, because probably in those circumstances, you wanted to leave everything to your spouse or civil partner. But if you have children or grandchildren, it automatically becomes more complex, because it basically says the spouse or civil partner gets the household contents and any personal effects, the first 322,000, and then half of the remainder of your estate, which means the other half goes to your children in equal shares. Now, that could in itself trigger an immediate charge to inheritance tax just at the moment when your surviving spouse or civil partner needs the money most. And so ordinarily, you would expect everything to be left to the surviving spouse or civil partner, and that would avoid a charge to inheritance tax at that point. So on the death of the first to pass away.
Mm-hmm.
It gets more complex on the second chart, because if you say, do you have children? And you say no, you then have to ask yourself, are your parents still alive? And if you say no, you then go on to the next level, which is, if you have siblings, are both of their parents the same as yours? And if you say no, is only one parent the same as yours? And again, if you say no, you then have to look to grandparents. Are they still alive? And if you say no to that, then you look at uncles and aunts. And eventually you get to the end of the chart and it says everything goes to the Crown or the Duchy of Cornwall. And that sort of level of complexity is completely avoided if you have a will, because hopefully your will will be properly drafted and will express the wishes for your money.
Mm.
And hopefully it won't be quite like the scene in an Agatha Christie novel where the spiteful matriarch of the family is determining who's going to get the house, who's not going to get the house, and so on.
It's a really interesting point, Stuart, because I think a lot of, I don't think I know, people I work with, one of their things is they don't want to cause hassle or chaos or anything that they can be avoided on their death, right? They say, I want to make sure that my children or my next of kin or, the beneficiaries can have something that is relatively seamless. Yet, if they're not taking action on that, i.e. they don't have a will, you could have that situation where, where people are being called on to go, where does this money go? And I have seen it. And I know, absolutely you would have seen this where there is a bit of a battle for this stuff, and it all just gets very soured. And I think if anyone was still around, the people that have passed away to see that, they would have taken a much different path. And it isn't, whilst it's a complex thing to do, it isn't necessarily that hard, is it? You go and get an expert like yourself to sit down with you and run through your life and what you've got, and to properly draft a will. It's a wonderful investment of your time and money to be able to make sure you can just park that and go, do you know what? I know where this is going now.
And towards the end of my book, we present an overarching plan that works for individuals, for both when they're very young and also when they're in that final chapter of their life, and should give individuals the confidence that their estate is going to be distributed in accordance with their wishes. There are a sort of couple of points that are worth thinking about. And the first one is about the choice of executors and trustees. The view I have come to is that you should ask individuals to be your executors and trustees who you believe will carry out your wishes. Sometimes that's strictly, sometimes there's a discretion, but fundamentally it's the people who you believe will carry out your wishes to the best of their ability. And that's to be contrasted with some organisations and institutions who insert into your will as executor their trust corporation. I think that in my experience, the ones which I find least satisfactory is banks say that they want to be your executor. And there's two reasons. They then claim a percentage of your estate as their fee. And secondly, you're dealing with a faceless organisation where
Absolutely.
Where you don't necessarily get an individual taking personal responsibility. I think the advantage of getting your individuals who to be your executors and trustees to carry out your wishes is that they don't actually have to do the work themselves. They can go out and hire professional services firms, just depending on what needs to be done. So that might be a land agent because you've got property to be dealt with. It might be an investment manager because you've got a portfolio that needs to be looked after. And it can also be the kind of people who are prepared to act as a professional trustee. And I think that's one of the key points that people need to focus in on. The second key point, though, very much depends on the dynamic within your family. But if you have a family where there's quite a lot of tension, it may be that you would not openly discuss your wishes with your family. But I find most of the families I deal with do have a very open and cooperative and collaborative relationship with either their children or their relatives. And they can have constructive conversations around what they plan to do with their estate and who's going to administer it. And if you can have that open conversation, where I think that gives you a significant advantage is that there are no surprises. So to take us back to the Agatha Christie novel, there's usually a chapter in there which is the reading of the will, immediately followed by gasps of despair that somebody has been cut out or somebody has been preferred. Yeah. That was unexpected. Of course, what then follows is a murder, but that's another story.
Yeah, the thing we all need to avoid, hopefully.
Absolutely.
Stuart, fascinating, because one of the things that I almost insist on when I work with clients on their financial plans and their retirements is when we start thinking about appointing executors, which quite often is the children or a brother or a sister, I often try and hold a family board meeting with them. It's kind of, well, actually, we don't need to go into details, but let's just all get around a table. So they know who I am. They know, I know the solicitor. We try and join up the approaches here because, as you absolutely rightly said, when you're not here, your executors will need professional help, probably. And so you probably want that to be consistent with the people that know you and that they know them and all of that stuff. So I think having that joined up approach and having the openness is crucial, and trying to encourage the openness, trying to encourage, particularly with people with their children, try and be open with them, unless there is legitimate reasons that you don't want to say everything, and there'll be many of those. But if there isn't, and it's just that you're fearful of having the conversation, or you don't. Let's encourage that openness to sit around the table, have that conversation, so everybody knows where there is. So as you rightly said, there isn't surprises and a murder at the end of it when you're not here.
Indeed. I mean, there is the exception to that, whereas if you know that your intended beneficiaries just argue amongst themselves, I might add sort of viciously, then you might choose to instruct either a professional advisor or the people you want to be the executors and trustees. You might say to them what you would want them to say to your family when there is the reading of the will. Because I think there is another point where there is that sort of level of disagreement or distrust within a family. Why would you enter into a series of conversations that you yourself, as the person writing the will, could find distressing, particularly if you're elderly or infirm, or you're, notwithstanding that you have legal capacity, your ability to think on your feet is not as strong as somebody who's younger. And so I do think there is a case where you know that having the conversation will create angst, particularly for yourself. The alternative approach does apply. But for most people, I find it's not a problem. And I think that's your experience as well, Dan.
Yeah, absolutely. I think just an openness to facilitate a conversation, right? They just want someone there, I think, to help facilitate it and be around to kind of, talk that through. So yeah, no, I agree. I do want to touch on one last point on this actually, because I think it is crucial. In a modern world, it sounds like I'm really old, but it is quite normal to have blended families, second marriages. And that does pose some more challenges and some more opportunities, if that's the right word, for actually some of the issues that we talked about. What considerations do you think from a high level point of view that should, that blended families, people on second marriages should kind of consider when they're putting together their wills?
So what I tend to find to be the case is that if somebody has a second marriage with children from the first marriage, the concern is that their share of the joint estate should still go to their children. Because if you leave everything to the surviving spouse, typically the surviving spouse can then change their mind as to who gets the money. So the worst case scenario I've come across is, let's just say it's a husband who's got 2 children by his first marriage, leaves everything to his second wife who has 2 children by her first marriage. And then after the husband has passed away, the wife changes her will and just leaves everything to her children only, resulting in the children of the husband being dispossessed. So there is, I think you see this quite often, that there's a strong wish, on the one hand, to make sure that the surviving spouse is looked after. But when that purpose has been completed, because they themselves have passed away, they would then want their money to go to their children as if they had still been married to their first wife.
Yeah. And one of the other scenarios that I've seen, Stuart, is where, let's take the same example, where the surviving spouse, the wife, remarries. And therefore, if it's all left to the wife, she remarries, and then she passes away, could then be, everything could be left to, without any provision in place, could be left to her new surviving spouse and maybe his children. So one of the first things I did when I had kids, etc., and was thinking about this, is trying to protect my half of the estate, to say, well, actually, if I passed away and my wife then remarried, at least my half is going to make sure it goes to, make sure she's looked after, as you said, but my half still retains to be for my children. But I have seen that in action before, and it's not a particularly nice scenario.
But the answer to it is to simply leave your estate in trust for the benefit of the surviving spouse. When the surviving spouse passes away, for that money to revert to your children. And it's a relatively straightforward step. The other, I suppose, thing to say in relation to a well-constructed will is a will becomes much more powerful if it's supported by a letter of wishes. So whereas a will, very often you think, has been written in using many legal terms, if you like, and is less accessible, a letter of wishes can be written entirely differently. So it can be a very personal letter, much more accessible, probably capable of being interpreted by your executors and trustees if required. And it just gives guidance, because whilst a will sets things out in stone, if you like, a letter of wishes can speak to the discretions that are available to executors and trustees.
Yeah.
And can guide them as to how to distribute the money. So, for example, if there is a trust fund and the idea is that ultimately the children are to be treated equally, but the letter of wishes says, but if one of my children becomes, for example, suffers a major injury, can't continue with their career, there may be some preference should be given to the child whose needs are greatest.
Yeah, no, absolutely. I think that's a key tip there for me, is that, I mean, a lot of people don't understand that, right? People that they don't understand that is quite a simple thing to put in place to help and do. It's kind of, they don't really think. I think a lot of people don't think beyond that bit, do they? It's kind of like there is a step beyond if you're not here. There's or maybe 2 or 3 steps that you can actually affect while you're here, and you can put in that document. I want us to move forward now to probably estate planning 102. That doesn't exist, does it? I don't know what that means. But the second part, and that is lasting powers of attorney. You mentioned something actually, Stuart, earlier on, which I think and I think it applies to LPAs, in this just like belief that my spouse gets everything, right, without any worry. Kind of, I'm married, so it's fine. There's no other legal things I need to worry about. They get everything. And I think that falls through to lasting the power of attorneys. It's kind of like, I'm married, it's fine, don't worry. They can make a decision if I'm not here, or if I need something to do with medicine or whatever that is. This belief that marriage is the thing. And when I turn around and go, it doesn't matter, like, i.e., like if you haven't appointed someone to act on your behalf, then the marriage thing is kind of, they still can't act on your behalf. And a lot of people go, well, that's wrong. No, it's like you want these power of attorneys in place. Without stealing your thunder, why should people set up a power of attorney? And can we go into the difference between the 2 power of attorneys that exist, and then maybe touch on some of the risks that people face if they don't have power of attorneys in place?
So the 2 powers of attorney, you've got one that deals with financial matters, and you've got another that deals with health matters. The powers of attorney can only be used where you have lost capacity to look after your own affairs or make decisions for your own welfare. So powers of attorney sit in the background in the hope that they'll never be needed. But if, for example, something does happen to you, then the people who are appointed as your attorneys can then step in and make decisions for you. So if we think about a power of attorney for financial matters, if you have lost capacity because, for example, you've been involved in a horrific car crash and you've been placed into a medically induced coma, clearly you can't do or say anything relating to your financial affairs. And this is where the power of attorney allows your attorneys to step in and do things on your behalf. There is one key thing, though, to remember about a power of attorney, is that they can only be used for your benefit. So if an attorney suddenly thinks, great, I've got a power of attorney over my elderly uncle, and I'm going to make a raft of gifts benefiting everybody, including myself and my family, that is not a permissible activity. If you were thinking of making gifts of that order, you need to go through an application to the Court of Protection, and you'd have to get a judge to agree that it was in your best interests. So, for example, if you've got somebody who's lost capacity, who's vastly wealthy, and they had been talking about lifetime giving to benefit relatives, that might be the right kind of circumstances for an application to the Court of Protection. Moving on to the other type of attorney, the medical power of attorney. Again, really important that there are people within your close circle who know what your wishes are should you, again, lose capacity. You've been involved in an accident or something's gone wrong with your underlying health and you're in a coma. It's really important that there are people who know what your wishes are. And, one of the wishes would be, I don't want any medical intervention that would accelerate my death. So, in other words, I want to let, if you like, nature take its course and see what the outcome is. But you also see other people put in place a medical power of attorney saying, well, if I don't come out of a coma within 30 days, please withdraw all medical support. If my doctors say I have no chance of recovery. And again, it's just really important, I think, that those who are closest and dearest to you do know what your wishes are. because they will be asked by the medical practitioners what your views are. And if it's written down, but in the sense of, on the one hand, saying these are the people I want to make decisions on my behalf, and perhaps allied with that, you've had a pretty detailed conversation with your GP, your general practitioner, saying this is what I'd want to happen in those very difficult circumstances. Then, although you can't speak for yourself, your wishes, as previously expressed, can be carried out. I think that's very comforting, not only for the individual, but those who are closest and dearest to the individual, that they're not having to make key decisions for your welfare because you've made them already. And it means that they can then focus in on their relationship with you, typically a loving relationship, and that can be the focus rather than having to deal with a whole part of difficult and practical issues.
Yeah, that's a key point, Stuart, isn't it? This is not about them having no direction, right? This is not about someone just having complete freedom over your money or your. This is about them having the ability to carry out your underlying wishes, which I think, as you said, gives people a lot of comfort. That's definitely going to happen.
There was a very interesting study undertaken jointly between The Economist magazine and an organization called the Kaiser Family Foundation, a US foundation. And they essentially surveyed people at different stages of their life, but in particular they focused in on those who are very much at the end of their life. And although we talk about inheritance tax as being the most hated tax, that didn't really come up as one of the priorities when somebody is very much at the end of their life. And if I just tell you what the key findings were, firstly, individuals want to maintain their financial independence. So they don't want to be beholden to somebody else that they've given their money away to. They want to have their own independence. And the reason for that is they don't want to be a burden on family members. So I quite often come across the scenario where relatives will have inherited money, assumed it's theirs to use, and the individual who's given the money away finds themselves having to compromise their end-of-life care. And I would suggest that's not a particularly good outcome. Another factor which came out of the survey is that individuals want to have a good death, whatever that means to them. But in particular, it's one where their own medical care wishes are followed. So that conversation with the GP saying, give it 30 days, but if it looks like I'm not coming back, and that's what the medical practitioners say, let's end the care regime. There's also another one, which is simply they say they don't want their family members to be burdened with their own care decisions. So they want to make advanced decisions. Some of the three of the quite interesting conclusions.
Yeah, no, so true. I think that's, and I think going back to the wills conversation, like having these conversations early, right? You don't want these, you can't have these conversations at some point, right? If something does happen like that, then there's no way to have them. So have them whilst you are kind of I don't know if anyone is sane anymore, but of sane mind. And if everyone is kind of, whilst you are thinking clearly enough to be able to, to have these discussions, I think it's so important.
I think you're absolutely right, Dan, because I also find that if you're having to have these conversations and you're very much at the sharp end of the end of your life, people tend to be much more emotional. And having these conversations when you can be possibly a little bit more dispassionate makes them easier, not only for yourself and your spouse or civil partner, but for others who may be close to you.
Yeah. I'm not a big fan of kind of the rational and irrational thing. I think we're very much perfectly rational based on our learnt behaviours and experiences, right? So, but kind of on that scale, you want to be as entirely rational and as emotionless as possible when making these decisions, and the earlier the better, right? I think that's definitely. So let's get into maybe this. We've mentioned the most hated tax a couple of times. And I think it was really important to set the scene around the wills and the power of attorneys, because that can help in a number of ways mitigate some of this tax or carry out some of the wishes that are there. So let's just quickly and briefly talk about the fundamentals of inheritance tax in terms of what we're thinking about, how it works, and what some of those common bear traps are that catch people out when they're planning or looking at their inheritance tax positions.
So the scheme of inheritance tax is relatively straightforward. Every individual gets a nil rate band of 325,000. If they are married and their partner has passed away, the individual who's passed away also has a nil rate band, which is transferable. So you can find somebody who passes away then has an exempt amount of 650,000. Everybody also has the possibility of what's called a residence nil rate band, which is 175 each, and it's transferable. So that can get you up to the first million of your estate being exempt from inheritance tax. Two key points to note about the residence nil rate band. It abates if your total wealth is over 2 million. And second point is that if you realise your estate is over 2 million, but you make some lifetime giving, which we would describe as a potential exempt transfer, if you don't survive the 7 years, that lifetime giving becomes what we call a failed PET, or failed potential exempt transfer. A failed PET is not taken into account in the £2 million calculation. But essentially, every estate of a husband and wife where they're leaving the home to descendants would get a £1 million exemption. And for many people in society, that's more than enough. But we also know that there are others in society who've accumulated more wealth than that, either through high earnings and not spending everything they've earned, or through inheritance, or through realising capital gains, for example, from selling their own business. And so you find that inheritance tax can bite quite quickly. And this is more so after the inheritance tax reforms announced in the October 2024 budget, of which it's fair to say publicly there's been quite a lot of criticism and concern. So the first one is that pension funds are now within the scope of inheritance tax, effective from a future date, which I think is April 2027 from memory. So previously, you could have had £1 million of unused pension fund when you pass away, and that would then become available to your dependents. Now, it's still the case that if you leave your pension fund to your spouse and civil partner, you get the spouse exemption, so there's no inheritance tax at that stage. But if you've both passed away and you leave it for the benefit of your children, the value of that pension fund gets brought into the calculation of the inheritance tax on your estate. And that's quite a change. The kind of clients who would have an unused pension fund are the ones who felt that they were never going to spend out the entirety of their pension, so they don't buy an annuity from a life insurance company. They self-invest. We hear of things like SIPs and SAPs SIPs and SASs, and other forms of pensions that you self-invest rather than buying an annuity. And it is the individuals who self-invested their pension are the ones who are caught by these new provisions. The other controversy caused by the October 2024 budget is the reduction in the amount of agricultural property relief and business property relief. The exempt amount is now £1 million, whereas previously it was unlimited. And if the value goes over £1 million, the relief becomes 50% of the value. So in effect, you end up with an effective inheritance tax rate of 20%. If you think of, and this is because the farmers have probably garnered the greatest publicity, there are not many farms valued at £1 million when you take into account the farmhouse that are actually viable as a farm such that they can generate extra money to pay this inheritance tax on a death. And that's the controversy. The greater controversy, which I think will occur over time, will be business property relief having the same restriction. Because when you come to value a business, what you do is you essentially take the sustainable earnings of the business and then capitalize it with a multiple. And let's just say the multiple is 5. So you'd look at a business and say it's capable of generating sustainable profits of 100,000 a year. And so the business is valued at a multiple of 5, so £500,000. And that £500,000 gets added to your estate, even though the objective is to keep the business within the family. So the family suddenly have to say, well, we've got £500,000 worth of value which we're never going to realise because we're keeping the business in the family. We probably ought to use a larger example. So say it was £1 million of profit. This is to help with the maths. So the value is 5 million. The first million is exempt. The next 4 million gets 50% relief. So that's 2 million left in charge. At 40%, it's an £800,000 bill. And people do not necessarily accumulate money to pay the inheritance tax on a death. And if you think of some of the larger businesses in the UK that are privately owned, you could look at, say, JCB, fantastic international business employing, I think it's about 40,000 people. I don't know how JCB is owned, but if it's owned by one or several family members, every time they pass away, the issue is going to have to be considered as to where do they get the inheritance tax from. So if you just say, for example, JCB is valued at, I don't know, £500 million, you can forget about the million exemption because it's trivial and say that's £500 million or 250 million in charge after the 50% relief. So it's 40% of 250 million, which sounds to me like £100 million worth of inheritance tax. And all that's going to happen is that for some of these families, and I'm not saying this is the case for JCB, but for some of the families, they're not going to be able to find the money to pay the inheritance tax. So what's going to happen is the business is going to have to be broken up. So bits of it are going to have to be sold, or it may be it results in the business having to be floated on the stock exchange. But whereas a family-owned business can make decisions that are exclusively for the benefit of the company, a public company finds itself subject to all sorts of external pressures like, well, what is the dividend? How are you investing? Why aren't you returning money to the shareholders when you've got no investments to make? What investments are you making? So you lose that power of destiny, your destiny.
Just on that point, I think, and this is I think the most common bear trap that I see is you've mentioned the bill, right? The IHT bill that you have, whatever that might be, 40% of something that's over the amount. But when I say to people, and, with the greatest respect, these are, I think, well-educated people, that they're not stupid and they know lots of stuff, right? They're not. When you say to them, oh, by the way, that bill's got to be paid first, right? That bill there has got to be paid first before probate can be issued and the estate can be settled. And they don't know this. There are so many people that don't know that bill has to be paid for. Now, there are things, if I'm sure you'll get into around, if it's in a illiquid asset, you get a bit more time and you can get loans out, etc. But ultimately, before the estate can get probate and be settled, you need to pay the inheritance tax up front, which I think just surprises so many people. And then they go, well, hold on a minute. If we think about a wealthy family or even like a small business, like you're saying there, how am I going to find that? How are my kids going to have £400,000, £500,000 of money to settle the estate? I think that's a big problem for people, and I think off that, what are some of the things that people can think about when it comes to making sure they can plan this and help that end of things, making sure they can settle the bill and settle their estate?
Well, I think you're absolutely right to highlight this point because I think I'm right in saying that you have to pay the inheritance tax within 6 months, or it will typically be interest bearing. Now, some of the assets within the estate, you can have what's called the instalment option, which is to pay over 10 years. And if you're thinking about agricultural or property that qualifies for agricultural property relief or business property relief, those instalments are interest-free. But if you had a portfolio of properties that are rented out to tenants, interest accrues on those instalments. And I think it accrues at a pretty heavy rate of about 7.5%, which we all know will absorb the entirety of the rental yield. And so if you'd hope that your successors were going to have a property portfolio that would provide them for an income, it's just not going to be the case. And so a part of the portfolio would need to be sold. There's another problem that relates to the administration of an estate, which is if you do take the option to pay by instalments, it makes it virtually impossible for the executors to say that the administration of the estate is complete, because they are still on the hook for the unpaid instalments of inheritance tax. So whereas we sometimes talk about the executor's year, namely, an executor should administer an estate within 12 months of the death, or have some fairly good reasons as to why not. And, and it is quite possible to have good reasons. If you take the instalment option, by definition, the estate administration is going to run for a decade. And how does that help society? Well, I personally don't think it does at all.
No. And actually, particularly if the people administering the estate are your children or your family members, it's like there is no clean break, grieving process, whatever that might look like. It's just horrendous for everyone involved.
I think if possibly your children, it's going to be less of an issue, because if they actually inherit the entirety of your estate, then they're the only ones who have the liability for the death duties, the inheritance tax. But if for whatever reason you've chosen non-family members like professional trustees to be involved in the administration of your estate,
fair point. Yeah.
They're not going to hand over the assets to the children on a promise that they will pay the remainder of the instalments of the inheritance tax.
Absolutely.
Because if they don't, as sure as night follows day, if the instalments aren't paid, HMRC will go after the original executors and trustees.
So, Stuart, what are some of the things that people can think about then? And one of the things that is becoming more popular with people I talk to is to ensure that liability, right? So you can get kind of maybe a reviewable whole of life policy that can give people a window of 10 years to maybe start actively reducing their estate through gifting and all of that stuff, trust work, etc. Because I think, it just takes away that peace of mind where there is a lump of money that's held in that can get paid into trust for the beneficiaries to have this immediate access to settle the estate. Again, a lot of people don't know those kind of things exist specifically for this work.
One of the particular outcomes of the changes to agricultural property relief and business property relief is, under the old regime, or the regime that existed up to the end of October, most people who owned property that qualified for 100% relief just didn't have to worry about their estate planning. They knew that they could keep the assets in their own name up to the point they passed away. Those assets would then pass under their will, free of inheritance tax, and there was no great pressure to consider succession planning. These new changes, though, do point to lifetime giving as being the way forward to mitigate your estate. Lifetime giving, essentially, you're either talking about making what's called a chargeable lifetime transfer, where inheritance tax may be payable on the transfer, but more probably you're looking at making what we'd call a potentially exempt transfer, which I've already spoken about in this interview. And potentially exempt transfers overhang your estate for 7 years. So you need to survive the 7 years for the gift to fall out of your estate for inheritance tax purposes. Which then leads on to, as you rightly point out, Dan, the issue of life assurance. Because where you've made a lifetime gift which has got a 7-year tail, you can actually purchase what we call decreasing term assurance. So the insured amount decreases over the term of 7 years. So the receipt will match up against the liability. And if you survive the 7 years, well, you've paid the premiums and you've got nothing back, but you've also not been on risk for what the inheritance tax might be. You then have a further form of life assurance, which is what you might call a whole of life policy. So this is designed to cover the situation where you say, I've decided how much I'm going to give away, but I'm going to keep this much for myself, for all the reasons that I gave when referencing the Kaiser Family Foundation survey. One of the key ones is I want to maintain my financial independence. So by definition, that probably means you'll have more money in your name than any exempt amount. Even $1 million might not be sufficient. I typically find people have got several millions in their name at that point, so that they've got sufficient income so that all of their care needs are met by themselves. And the way whole of life insurance works is that the policy can either be a level premium for the entirety of the cover, or it could be a single premium where you put a very large amount of money up front, or it could be a low-cost option. It's low cost in 10-year slices. The risk in the first 10 years of a policy for a 50-year-old is a whole lot less than the risk on an 80-year-old, as for obvious reasons. And so there's all sorts of ways of setting up a whole of life policy. It can also be set up on a joint life basis. So in the event that it's to cover the liability of a husband and wife, the policy is set up on the basis of it will pay out on the second death.
Yeah, I think.
And
Yeah.
and I think you allude to this as well yourself, Dan, is that if you then write your life assurance policy in trust, the proceeds then pass outside of your estate for inheritance tax purposes. So you don't pay inheritance tax on the policy proceeds, but the policy proceeds are available to pay the inheritance tax on your estate. And that can be a very, very good outcome. One of the things I find with whole of life policies where the premium's paid annually is that it could well be that the parents start paying the premium, but as their circumstances change and they give money away, the only people who really benefit from the policy are the children. So the parents invite the children to pay the premiums because they say you're going to get all this money at the end of our lifetimes.
Yeah.
So why wouldn't you pay the premium if it's going to benefit you? And for some children, they can afford it and some children can't.
Yeah. No, I think it's, and actually, again, if we think about bear traps, I have started working with people that have gotten in a whole of life policy in place, but they didn't put it in trust. It's like, you see that, I've done that, it's fine. And you get the details of the policy and you look at it and you're like, just to let you know, that £800,000 that you're covered, when that's coming back into your estate and you're going to get, so I think that's a big thing. And actually another thing I see for people where they have death in service. So it's kind of like you have this big death in service policy from your work. And if you pass away, that can fall, like an 8-time salary can fall into and then all of a sudden the estate's just ballooned up out of nowhere.
Yes.
See that quite a bit. I think just as we start to kind of get on the home straight with this, Stuart, the gifting thing's really interesting to me because you've alluded to a number of things here around potentially exempt transfers, chargeable lifetime transfers, the 7-year rule, around gifting, and as you stated there, I think once you get past year 3, you're technically kind of in the money, right? I mean, it starts reducing down your liability. The other key thing for me there is that it's quite often that one of the couple, if you're in a couple, has to survive the 7 years, not just, you both have to survive the 7 years. No, I've got that wrong. Other way around. One of you just has to survive the whole 7 years, as I said first.
Well, it's not that simple because at the point of making the gift, you've got to decide who's making the gift.
Yeah. Well, absolutely. So I talk to people about making sure you do it together. Like if you can do it jointly, and I've seen that before. And actually, when just your take on this, where they've got 2 children as well, like it's like, oh, I'll make, even if you do gift number 1 on Monday, gift number 2 on Friday. Gift number 1 is the first gift, could take up the whole inheritance tax band. Child number 2 has now got the full liability of the tax, right? The order that you give, when you give, and how you give is so important.
And that's also very true because if you're also involved in putting money into trust funds, you're not only looking back or will be looking back over the 7-year period, but you've also again got to then look back at your history of giving money away because that can have an impact on how much tax is paid if you die within the 7-year period. Yeah. It can get all rather complex.
It does get very messy, right? Very messy. And I think that's why, your book is a wonderful place for people to start thinking about this with your flow charts and you thinking about how this affects. And then I would strongly recommend that no one goes this alone, because I do think it takes away, particularly if you get into retirement, you want your time to be able to enjoy, to do stuff, not to constantly have the worry of this stuff sitting on your shoulders and thinking about it. Working with professionals will take away that worry and give you peace of mind that, this is done and reviewed. Because that's the key thing with all of this as well, isn't it? Your relationships might change. What's once was your executor might need to change. How many times have you seen it where wills haven't been updated and stuff and people have remarried? So it's still, everything's being left to the ex-husband or wife. So having someone on your side, making sure that you're constantly challenging this and updating it and it's in line with your wishes is so important.
Yes, and as a rule of thumb, I think people say you should always review your will every 5 years, or in the event of a major change within your life. And I think that's a good adage. You're very kind about what you say for about my book. You may have in mind the foreword, and at the end of the foreword, the lady who wrote this says, "This is the book advisors in this area will want their clients to read, because it will mean that it's no. I mean, the book is no subject for professional advice." But if, as a client, you can turn up before your trusts and estates planning lawyer, having read the book, you'll be so much better informed about the things that you would like to discuss, and it will make the whole process much, much easier. And that's not to say it's in any sense a substitute for advice, but it does mean that you can cover the options a whole lot quicker, because you'll have a better understanding of what you can do and what you can't do.
Yeah, and from personal experiences, the meetings that you have with people that have had some sort of education of this beforehand are so much better. They're ready for a much more open conversation. They're already equipped with the information they need. They've already probably thought a little bit. One of the challenges I see when these meetings are done is if someone says, well, who do you want your executors to be? That can stall the meeting right there, right? Because they're like, well, hold on. I mean, brother, nah. One of my children, can't get them. We need to think about this. It's like, well, actually, if you think about this beforehand and you have a conversation with your spouse, or you think about, then you're in a much better position to be well informed to go and have a proper productive meeting with the professional that you sit in front of.
Indeed.
So one final question for you, Stuart. When, as we've said, I think this is a complicated scenario that people actually don't believe or don't understand how complicated this can go. And in my experience, that's people's reactions when they sit down with people like you and they have these conversations. When should people start seriously thinking about this? And what are some, I suppose, quick wins for people to really start thinking about? What are the foundational stuff? And it might go back to the conversations we've been having, but as a summary, when should we start thinking? What are the first things we should start thinking about? And what are those first steps that people should take to give them the peace of mind over their estate, and making sure ultimately that their money gets left to people that they want it to get left to?
Yeah, I think it very much turns on what stage of life you're at. So, for example, if you've just graduated from university and you may have some money left to you by relatives, you're obviously looking at a very extreme scenario that you die in your 20s. Your will might simply say, all I want is for my money to go to my siblings, my fellow brothers and sisters. And that's, if that's what your wishes are, that's absolutely great. But as you progress through life, your situation becomes more complex. So you might marry, you might have children, you might accumulate larger amounts of wealth. And I think you just need to just reflect on what you really want to happen to your money in the event you pass away. And again, if you follow the plan we set out in the final part of the book, what it gives is a structure that works almost regardless of what stage you are in life. And it just sits there in the background doing nothing until it's called upon. And I like that particularly because from an individual's point of view, it means they remain in control. They don't have others interfering in decisions relating to their money. But in the event that the inevitable does happen, and we never quite know when that's going to be, it does mean that everything has proper order and your wishes can then be carried out. And it seems to me that is the most important thing.
Totally agree. Stuart, thank you so much for your time and joining me. Where can people find you? Where can people get your wonderful book? I'll put all the links on the show notes, but I'd love people to connect up and make sure that, not only for people that are listening to this that are thinking about their own situation, but for advisors that are listening to this podcast and this episode, to have a resource that they can give to their clients to help them educate, as you said, that first educational piece, which makes the process much better for everyone and maybe speeds it up in a good way. Where can people find you, connect up and get the book?
So you can get the book from Amazon. It's
Wonderful.
Available as Kindle or paperback version. If you want to contact me, the best way to do that is through my firm's website, www.ritchiephillips.co.uk, where all my contact details can be found. And not unsurprisingly for somebody in my position, I'm also on LinkedIn.
Aren't we all? Aren't we all? Well, I'll put those details in the show notes to make sure everyone knows where they are. But Stuart, thank you for taking time out. It was wonderful to have this conversation with you. I'm glad we persisted and got it in the dive when we're both well enough to have it. Thank you for writing the book and highlighting all of these real fundamental key topics when it comes to people's lives and their money. So I really appreciate your time.
And Dan, thank you for conducting this podcast. It's been very enjoyable.
Thank you. And that just leaves me to thank everyone once again for joining us on the Humans versus Retirement podcast. Until next time, take care.